one I may be allowed to mention. Because style suspicion. Because I have been instructed.
Yes.
Sorry.
You are appearing for?
For the associations were not mentioned.
For the Bombay
Yes.
Bar Association.
All the three
You
associations.
are appearing for Bombay Bar Association,
Bombay Bar,
Advocates Association of Western India,
and the incorporated law.
and the incorporated law.
Also,
There must be somebody for the High Court.
So I appear for the state of Maharashtra.
Now, what has happened is that the reason we thought we should monitor it is that there was a judgment of the High Court.
That is so.
Right.
Now, pursuant to that, lands have been allotted to the High Court at Bandra East. Now, possession has still not been handed over to the High Court. There are two aspects which really are of concern to us. One, that possession has still not been handed over to the High Court, and many of those lands are still in occupation of staff colonies. Now, the state government has to start the process of getting that vacant and hand over possession to the High Court so that construction can begin. The second aspect which, Mr. Solicitor, we thought we should request your presence and really your good offices for the Union of India is that today's building of the High Court now is over 150 years old.
The heritage,
It's
modern heritage.
Now, I don't think any structural audit has been carried out of the building since 2017. The High Court is in dire need of accommodation to shift some of its offices because we will have to have a structural audit in terms of safety conducted of that building. And there are other adjoining buildings which are available. So until the High Court's own structure comes up at Bandra, if the Government of India can perhaps, for instance, there is one MTNL building. There is another building which is of the Central Telegraph Office, just across the road from the High Court. Now, Telegraph, of course, has become obsolete, so the CTO building is available. If the Government of India can, sort of... Yes, exactly. Parade. So, if the Government of India can intervene, facilitate with the Government of Maharashtra so that in the interim period, that area can be given to the High Court, which is critical for its functioning. Because otherwise what is happening is that the whole building is carrying the weight of the books, the furniture, everything. And about a year ago, there was an incident in the library where a whole slab fell. And fortunately, none of the lawyers were there present in the library at that particular time. It happened in the night.
I may, Lord,
Air India building would also be available now. I think it's taken over by Government of Maharashtra.
Lord, I may, Lord, inform your lordships about something which will not be possibly within your lordship's knowledge. Lord, few responsible individuals, responsible members of the bar met me in a personal friendly capacity for this problem, Lord, say about 20 days or so, Lord, before. And we discussed the problem regarding the shifting of the High Court. There is no denial that it needs to be shifted. In their presence, I called the Honorable Deputy Chief Minister, Lord, of Maharashtra, that this is the problem. He said, I am aware of the problem. Ask your friends to come to me at any time because there are some internal issues, but I will not say problems. Some wants a land, some may have preference.
No, but now that is finalized.
Now finalized. It has to be...
What else?
Sir, may I, if your lordship permits, just give a chronology.
Yes, only a minute. So he said...
Direct AG wants to say something.
I'm just completing. He said, come and meet us, whatever is to be done will be done. And he said, that's my promise. We are with the bar.
Only one thing now, let's have clarity so that, there's no uncertainty about it. This land at Bandra East has been allotted to the High Court.
Correct.
There was some, there just happened to be a conversation in the court, I believe, in regard to some lands at Goregaon. Goregaon is not convenient. Those lands are earmarked for the Maharashtra National Law University. Bandra is by all circumstances more convenient for lawyers, litigants from different parts of the city. So let's now first and foremost bury this notion that some other lands apart from Bandra are going to be allotted.
We are given to understand. Yeah. I'm not aware of even geography of Bombay.
So, Mr. Advocate General, what do you have to say, Dr. Saraf?
Lords, may I just clarify, Lords? Just to give your lordship's background, Lords, because I respect that the court has taken cognizance of the matter. And Lords, we are here to assist the court in every which way. Lords, I am myself a member of the bar. But I wish that the bar at least would have inquired from the court or at least from me as to what are the steps taken. Just giving your lordship a few because this plot of land has been identified after a great deal of discussion with the High Court. High Court had identified and approved this plot of land on 3rd of October 22. It was known that there are government colonies on this plot of land and that this is a part of an integrated development of that area. Immediately thereafter, in March of 23, a GR was issued by the higher government. And after that, several steps have been taken to immediately vacate that plot of land and to try and see as early as possible the land can be handed over to the High Court. Thereafter, on the last occasion when the court took up the PIL, which the Bombay High Court is seized of, an entire plan of action along with a plan was given to the High Court, pointing out in what stages the land will be allotted. Giving your lordship a few figures, a total land of around 30 acres, 30.16 acres has been identified for the High Court, out of which 8.5 hectares is for the High Court buildings and other areas. 8.5 hectares.
And 30.16 is acres.
Acres, yes.
Right.
And around 3.63 hectares are for the lawyers' chambers.
Yes.
Because I've been a part of this journey as a part of the Bombay Bar Association for several years, so I'm familiar with this. The bars were called upon to give their requirements and all, and this land was identified. Because in the plan which has been given to the Honorable Bombay High Court on the last occasion, the state has identified that by December of 24, 9.64 acres will be vacated.
How much?
9.64 acres.
Yes.
By March of 25, 13.73 acres will be vacated and handed over. Then, there in the periphery of the plot, which I can demonstrate from with a plan on the next occasion, there are certain government colonies. They will not come in the way of commencement of the construction. The main central area will be vacated, and the construction can start. And in the periphery, whichever government colonies are there, the phase-wise vacating of those is also given to the High Court. Plus, the thing is, this is a whole integrated development. The construction for shifting these government offices.
December 2024 is too long. Why should the government? I mean, you allotted the land. This was March 23. Now we are talking about December 24.
May I just clarify why?
Take steps to get these lands and vacated and handed over immediately to the High Court.
Plus, the difficulty is when the land was also allotted, it was known that there are existing government colonies on that plot of land. The building
is not like a builder being told that, well, there are existing government colonies. You are giving it to the High Court.
No, I understand, but I need to shift those.
Given the land now, this is the duty of the government to hand it over immediately. Can't be December 2024. By December 2024, construction must begin. Because that's one thing which we'd like to ask the High Court about what steps is the High Court taking to at least draw plans, the tendering.
Because I'll also tell you, Lordship, just 2 or 3 more facts. Just 2 or 3 more facts. Because the High Court appointed a subcommittee of the.
And Dr. Saraf, those staff colonies which are in the occupation of people there in the colonies, the government must provide alternate accommodation to them and hand these lands over.
Yes, plus the buildings for shifting them are at an advanced stage of construction. The OC for one building has already been received. And the other buildings, this was always told to the High Court even when this land was identified. And so far as the Goregaon land is concerned, that was just a casual suggestion made by the petitioner in that petition. And they said that now the Goregaon land can be reconsidered. It was just a casual observation saying just let us know whatever is there. There is nothing that the court has asked us to shift the land from Bandra to Goregaon. This land is identified.
That's over. Well, let's not even think of now Goregaon. We have identified now the government has already made an allotment of the land at Bandra.
Yes, that is what it is.
Bandra. But Dr. Saraf, we would like the government now to be more proactive. You can't now wait
until December
2024.
But please bear with me only to this extent that I need to have some place to shift these existing staff. Their buildings is a part of an integrated development of the whole area, and this was known even when we identified the land. So give us that much leeway. We are doing every step possible to ensure that this land can be vacated as expeditiously as possible. I'll surely put it to the government to further expedite it to make the timeline as short as possible. so that the construction can commence.
At the highest, you can take the period of the monsoon, and monsoon normally ends in the first week of September. By September, you must give lands to the High Court, because otherwise, and second, simultaneously, there has to be an effort to start the other process, because this is all government land. Now, in the meantime, why wait for the actual handing over of physical possession to start the drawings, the plans, the tendering process,
and
design?
The drawings are, I think, ready. Almost ready.
Plus, may I also update the court on that? The High Court appointed a subcommittee, including of Public Works Department officials, to visit various High Courts. They have visited just recently the Lucknow bench, the Jharkhand court, the Jodhpur bench of the Rajasthan High Court, and the Delhi Arbitration Center. And they have visited with the court officials all these benches to have a look as to how those buildings have been developed. And immediately a report has been given to the High Court. The High Court now is in the process of initiating the entire process of preparation of plans.
But that shouldn't come in the way of handing over the land to the High Court. I mean, you can go and visit the High Courts for design.
Secondly, you should also understand ground realities. You can't evict the person's overnight.
I understand, Milord. I'm not saying it's adversary.
Plus, the thing is, we did not.
It's not adversarial. Let's all work together. Is all.
Your main concern was that the government is not moving at a right speed.
That's it.
And then about the party Goregaon thing.
It's not that the government told the government that it will be located tomorrow. It was known to us, and please give us that much leeway to make sure that our staff can be shifted in a building which is under construction. We'll try and expedite it as much as possible. Please take it from us. The government is equally concerned and was equally interested in making sure that the best possible infrastructure can be provided to the High Court.
And Dr. Saraf, the third aspect now about giving the High Court not additional premises in the vicinity of the High Court. Because the construction may take 2 to 3 years. Because something which is not a small building which is being constructed. So in the meantime, I think we have to ensure that a structural audit of the present building is carried out immediately before the monsoon, so that we are aware of what the safety concerns of the High Court premises are.
We'll get it.
Second, we would like the government of Maharashtra and the government of India to sit together and tell us, say by next, we will keep it, say next Friday, and which is the building which they are identifying. Let there be a common meeting between the Chief Secretary to the government of Maharashtra, a representative of the Union government, and the Chief Justice in the course of this week, so that alternative building is identified, and then we are told on the next day that this is the building which we are providing for the High Court to shift its staff, so as to reduce the pressure on the existing building.
As an interim.
We are happy to do that. Whatever is required from our side.
Fire in Mantralaya. The Mantralaya building was not put in use, so they had made alternate accommodation for Mantralaya offices in Kuprej and Kappared, some areas in Nariman Point. There are 3 or 4 buildings belonging to MTNL. One is just across the...
There is no resistance or reluctance. It has to be putting our heads together and that shall be done.
We'll do it.
On the alternative building, please make a statement before us by next Friday. We'll keep it on the 17th, which is the last day before we close, on what has been identified, so that then we will pass an order that, well, this has been identified. Other issues such as the financials is between the two governments, the central government and the state government.
It's a small issue. I didn't speak on that day to the union government, but state government at a personal level did tell me, the deputy CM, that finance is not a constraint, land is not a constraint, the will is not a constraint. We can sit together and finalize the plan of action. We are full in favor of a new High Court building. There was unreserved statement and in presence of some responsible members of the bar.
All right, actually, pass a short order then. The assumption of the, we pass that short order. The assumption of the jurisdiction under article, the assumption of the suo motu jurisdiction by this court has been premised on the extreme urgency of the extreme urgency in regard to the accommodation needs, of the needs for proper accommodation for the High Court of Judicature at Bombay. Full stop. The existing building is well over 150, nearly 150 years old. Full stop. The government of Maharashtra, on 3 October 2022, the High Court approved the proposal of the government of Maharashtra to allot land at measuring for the allotment of lands at government resolution was issued in March 2023. Full stop. Accordingly, steps are being taken to hand over vacant possession to the High Court. Full stop. The Advocate General has stated that a total area of 30.16 acres has been allotted for the purposes of constructing the building of the High Court and other pertinent facilities, including chambers for lawyers. Full stop. This comprises an area of 8.5 hectares for the High Court building and 6.36 hectares for the chambers for lawyers. Full stop. It has been envisaged by the state government that by December 2024, an area at measuring 9.64 acres would be vacated from the staff colonies and handed over to the High Court, while an area of 13.75 acres would be handed over by March 2025. Full stop. It has been stated that there are staff colonies on the periphery of the land which has been allotted to the High Court, but that this would not come in the way of the progress in the construction for the High Court. Full stop. There are three aspects of the matter which would warrant immediate attention. The first pertains to expeditious steps being taken for handing over vacant possession of the site to the High Court. Full stop. We are conscious of the humanitarian facets involved, since since staff colonies exist on the land which is allotted to the High Court, and the residents and the occupants would have to be relocated elsewhere. Full stop. Conscious as we are of these aspects, we are of the considered view that the state government must now act with all alacrity and substantially expedite the original, the allocation, the handing over of vacant possession to the High Court, so that construction can commence at the earliest. The second aspect relates to the need of the High Court for the allotment of additional space in the vicinity of the present building, which is situated at Fort Mumbai. Full stop. The existing building is bearing the brunt of the offices, so of several offices, as well as the judges, as well as the courtrooms, bar facilities, and chambers for judges. Full stop. The need for the High Court for the allotment of additional space is pressing. Full stop. We have requested Mr. Tushar Mehta, the learned Solicitor General, to intervene in the matter so that his good offices can be utilized to bring about an early resolution in consultation both with the union government and the state government. Full stop. There are buildings in the vicinity which may be utilized for that purpose, for the purpose of the High Court, and the financials in that regard would have to be worked out between the union government and the state government entirely at their end. Full stop. I have therefore requested that in the course of the ensuing week, a meeting be convened with the Chief Justice with the learned Chief Justice of the High Court of Judicature at Bombay, and the building committee which would be attended by the Chief Secretary of the Government of Maharashtra the Learned Advocate General, and a sufficiently senior officers and officers at a sufficiently senior level of the union government.
Yes.
Full stop. We also request the Learned Solicitor General to join in the meeting online. Full stop.
Whichever, even physically, if I need to,
online. If
it will be a miscellaneous week.
It will be a miscellaneous week. So now, actually,
we can't afford not to have you here.
By the way, there is a little. I must tell you one. Judges so hard over the term that we do not have enough matters for miscellaneous week now.
Yes.
So, this is a very different situation. This anyway, more of that later. The third aspect, we would expect that this court would be apprised on the next date of listing of the decision which has been taken in that regard. Full stop. The third aspect pertains to the commencement of the process for preparing the drawings and designs for the new buildings and pertinent facilities of the High Court. Full stop. The Advocate General has informed the court that a subcommittee was constituted by the High Court, which has visited several High Court buildings in the country, including the buildings at Lucknow, Jharkhand, Rajasthan, and Delhi. Full stop. We have the considered view that the High Court should in consultation with the CPWD, proceed immediately to a stage where the drawings can be finalized, so that the tendering process can then be initiated. The antecedent work need not await the actual handing over of the possession of the building to the High Court. Full stop. Having flagged the above three issues, we now direct that the proceedings be listed before this court on 17 May 2024 at 10:30 a.m. when the court can be apprised of the progress which has been made on all three aspects noted above.
Plus, only one clarification that there are also some encroachments on
in order to ensure the structural safety of the existing building of the High Court, the PWD shall immediately have a structural audit of the existing premises carried out, so that this court can be apprised of these safety and other related aspects of the existing building. Full stop. The court may be apprised on the next date of listing of the steps which have been taken in that regard.
Please.
So
I just wanted to clarify one fact.
They say Public Works Department, Maharashtra. Anything else that we have to say?
May I just clarify one fact?
Mr. Advocate General, you and the Learned Solicitor, you just both need to push the requisite authorities.
When the question...
To get it done, only one clarification may I please on record.
Justice Gawai is a witness for the way I work.
Mr. Advocate General, yes.
Sorry. When you have said that there are government colonies, there are also some encroachments and steps are also being taken for removal of glass. As a matter of fact.
While editing the order, I'll mention the encroachment. Sorry. Mr. Thakkar, of course, you are represented by Mr. Nikhil Sakadande, but would you anything that you and Mr. Venkatesh Don, the learned senior counsels, would like to mention to us, which we have missed?
Well, for the time being, this is sufficient, but we fear that the structural audit report will not be very favorable.
You fear what, Mr. Thakkar?
The structural audit report will not be very favorable. We may be required to vacate the High Court premises very soon.
No, I don't think so, because when I was the chairman of the building committee, we had carried out a structural audit. And that time, whatever lacunas were pointed out, those were corrected. So,
That we have to reduce the burden on the building, then the non-essential amenities can be moved out. That's what we will have to do.
But there are a lot of leakages.
The library
The
library is on the ground floor.
There are a lot of leakages during monsoon.
So that obviously, we are not coming. And one more thing that we'll also say, the pendency of these proceedings, the assumption of jurisdiction by this court shall not in any manner operate as a restraint on the High Court, both on its judicial side and administrative side, taking necessary steps in implementation of the decisions which have already been taken for the shifting of the building to Bandra East.
My lords, may I just suggest if someone can from ASI can also join the meeting, since it's a heritage structure. Archaeological Survey of India.
Let the Chief Justice can also. The Chief Justice will be at liberty to nominate any other members to attend the meeting.
Or say, PWD will.
We already have an heritage architecture. Who,
yes, my lords. Yes.
No work can be carried out without her permission.
Yes.
Anything else, Dr. Mr. Sakadande? Anything else that you want to say? Mr. Dond, anything else? Since both of you are on the line.
He's on mute.
Unmute karna padega.
Don't you are mute. You'll have to unmute.
No, they'll have to unmute.
to mention one
Just
fact.
send an email. Send me an email, yes.
My lords, I have mentioned.
Don't worry, then I'll take cognizance.
I will take 30 seconds. Lords, this matter concerns the Jeevan Jyot building in Mumbai, which is in a dilapidated condition, my lords. There are orders of the squad for
All in the email. Just say it.
10, my lords. So 3 judges required, my lords. That's the difficulty. And your lordships will.
I've already allocated a 3-judge bench yesterday, he says. Last night I allocated a 3-judge bench.
Deeply obliged.
Email now. Then I'll deal with it, yes.
Lord, item 10, there were 2 matters which were mentioned yesterday. Your lordships are directed. Lord, I'm sorry, my lord. With reference to item number 10, there were 2 matters which were mentioned yesterday. Your lordships are directed those matters to.
Problem. All matters will because of the same.
My lord, we had given a letter to the registrar also.
Yeah, no difficulties. Everything will be listed.
But it has not been shown in the list today.
Makes no difference. Yeah.
So broadly, Lord, in this group of matters, there are 2 separate aspects involved. The segregation part is one word.
Mr. Paul, you can have a seat. Why are you standing? Why do you have a...
My dad requires me to stand longer than sitting. That's what I was advised, so I avoid sitting for too long. Sorry. That's the reason I stand.
So far
Do
as
some mobilization exercises for the back. That's a professional hazard for judges and lawyers.
Yes, right.
So long as you keep your back mobilized, the lower back mobilized, by doing some stretches, that is very crucial.
Advice so
Just 10 to 15 minutes, but we all tend to neglect ourselves,
This can be debilitating.
Oh, it is completely.
And with some people, Lord, we have to sit for some time and stand for some time, and I was standing table.
Even for conferences, that desk now helps a lot, my lords. Stand and do conferences.
Yes.
That's very helpful.
So you do that, is it?
I do that. I've started doing it now. So it helps not sitting through the conferences myself.
It's better that lawyers start doing this from an early age, rather than wait for us to reach our age, and then it becomes difficult to resolve. So there are 2 aspects.
Yeah.
As I said, the segregation aspect, whether the candidates who have been found to be tainted, or rather the tainted and untainted, can they be separated? Is there enough material on record to segregate them? And whether the defects found are so widespread that the whole must go, the whole selection process.
That is one part. The second part, Lord, with which the state is concerned, because under the Act and the rules, there is a central commission which makes the selection, and there are boards, regional boards, which the board of secondary school, the board of higher secondary school, the board of madrasas, so who make appointments first. The state's statutory duty is limited to creation and sanction of posts and bearing the burden of salaries. So they do not come directly into the process of selection or appointments. Now that is not to say that the states overall are not responsible for the education in the state, but the various selection processes which are held from time to time are in the domain of the Central Commission and the boards. So I am confining my submission on behalf of the state to clause 8, which your lordships had stayed for the time period. I am not concerned with the segregation part. The commission's council and the other learned councils who are representing the candidates who are affected, they will be assisting your lordships on the question whether segregation is possible or not. They have the material to show. I am only confining to clause 8 direction which has been issued and stayed by lordships.
Yes.
Incidentally, my lords, on 23rd of November 2022, Justice Gangopadhyay had for the first time by an interlocutory order, directed CBI inquiry into the question of creation of supernumerary posts. That order is at page 506, at page 515, and in an SLP filed by the state, my lord, the Chief Justice was pleased to grant an interim order stating that, which is still pending, that is on 25th of November 2022, which is at page 518.
Yes.
That matter is still before the lordships. And one of the reasons, Lord, for this intervention by this court was that none of the writ petitions involved any challenge to the order of the state government creating supernumerary posts. That was never in challenge. The lordship turns to page 518 of volume 2.
Yes.
And the matter came up before Justice Gangopadhyay on account of the fact that the Selection Commission had moved a IA, which they call CAN 2 of 2022 in this matter, where they sought permission from the court for creation of this supernumerary posts, but it appears that inadvertently or whatever it be the motives, I do not want to go into that, but they mentioned to accommodate illegal appointments. The idea was that when the appointments are set aside by the court on account of these corruptions, etc., and there's long drawn litigation which is going on in that court and this court, so in the meantime, some supernumerary posts may be created so that those who are in the wait list, they could, regarding whom there is no issue as yet, so they could be accommodated. For example, in one case, this lady Soma, she had approached the High Court and the High Court itself directed, her case was that some people who are lower down and not in the list have been appointed.
That is a medical case.
Medical case, so therefore that was appointed. Now, If you kindly see page 519, item 6.
Yes.
Lordships have extracted the order of the learned single judge from the High Court. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified, it is humbly proposed that apart from giving recommendations and appointment to genuine candidates as observed by this Honorable Court by its order dated so-and-so, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid. Such proposal will result in no loss of jobs and enable such appointees to have means of livelihood. However, in the event of such proposal being accepted, appropriate directions be given that such persons do not have seniority over those eligible for appointment. So while this order direction was being passed, the state in fact appeared and told the court that this is contrary to the state's order creating the post, because that was meant for waiting list, not for invalid appointments. That those who are declared illegal, they will again come back through supernumerary posts. That was not the intent, and we produced that order. But even after production, nobody challenged that order. Even that's what I'm showing his purpose is, nobody even then amended the petition to challenge that order at all. And the Lordships have then murdered at page 509, paragraph 4, state this. In paragraph 9, page 520.
Yes.
So this petition is pending, notes. The question is identical whether the... Yes. So neither it was an issue, nor it was made an issue after production of the order, and it remained as such because my lords had stayed it. Now, the other thing is that with respect to these 6,000 to 861 posts which was created,
6,861.
Kindly turn to page 367 of volume 1. The proposals had come from the commission and the board to the state government saying that they have themselves detected a lot of cases of rank jumping and all that.
Yes.
So they themselves did it. So since they had detected, they recommended that from the wait list, that was their recommendation, which was accepted. And kindly see at page 367, having recorded the proposals at the bottom of the page 367. Now therefore, in exercise of power conferred under section 19 of the West Bengal School Service Commission Act 1997, the governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staffs as detailed at para so-and-so for absorbing the wait-listed candidates in the supernumerary posts so created as per approval of the state cabinet. And please turn overleaf. In exercise of the powers under section 3.2 of the West Bengal Board of Secondary Education Appointment, Confirmation, Conduct and Discipline of Teachers and Non-Teaching Staff Rules 2018, the governor is further pleased to direct that appointment letters to such wait-listed candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extant rules, subject to the outcome of pending litigations before the High Court of Calcutta. So there was no attempt to overreach the court.
Can we just go back to that order for a second?
Yes.
That's the page, Annexure 7, right? Page 367.
Yes.
Right. I was just trying to locate it up now.
I'm so sorry. At the bottom of the page I was getting that. So I think PDF is different also?
398.
398. I'm so sorry. At at the bottom of the page is now therefore in exercise of powers conferred under Section 19 of the West Bengal Service Commission Act, the Governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staff as detailed at para 4 for absorbing the waitlisted candidates in the supernumerary posts so created as per approval of the State Cabinet.
Yes.
And the next page, 399, that's PDF 399. In exercise of powers under Section 3.2 of the West Bengal Board of Secondary Education Rules 2018, Governor is further pleased to direct that appointment letters to such wait-listed candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extant rules subject to the outcome pending litigations before the Honorable High Court at Calcutta. It was all subject to the High Court that if they are set aside, in that event they are to be accommodated. That was the spirit with which this order was issued, and keeping in mind the spirit, barring Soma, nobody else was appointed at all. The posts remained vacant.
What was the occasion to accommodate 6,800 waitlisted candidates?
The objection really will be now this, that if at present there is no question of appointment because once the whole selection process has been found to be vicious.
But why did the government create, what is the...
That was during the process. During the process when the selection list this judgment had not been delivered, in between the process, there were various inquiries being done, one by Justice Bag's committee, then by CBI, affidavits were filed. Commission itself was required to go into it, and they also filed affidavits showing how many rank jumpings, etc.
This selection related to which year?
The same selection was. That's 2016.
Right, and the government created posts in 2022.
They were creating because what happened in this case that all selection list was finalized in 2018. Then January 2019 all appointments had been done. Now this challenge itself was raised in the year 2021, that's after 2.5 years. So that's why in the process, because the records which are to be preserved for 1 year, they were weeded out. All this happened because after 2.5 years, therefore all this problem was arising. So, of course, the problem was of our own making, so we are not saying.
Suppose a candidate on a select list or the waiting list were to file a writ under 226, give me an appointment. The simple answer would be to such a petition that, well, what is your vested right? After 6 years, you can't even get appointed.
Yes.
Because the tenure of a wait list can never be that long.
Yes.
Now, this was 2016.
No, in fact, in 2019,
the government creates 6,800 supernumerary posts.
So, in fact, 2019, it was already declared that this panel is dead. Now, because the writs are being filed in 2021, 2022.
I only add one thing. Because the reports came that there are potential irregularities, and the matter was pending in the High Court, the fear was that tomorrow if they are struck down, there will be a huge vacuum. It was in that background that a suggestion was made and a full cabinet note after discussion was prepared that in case that were to happen, where would we go without 25 or whatever 10,000